And I see Mr. Phoenix and Ms. Anthony are both now in the virtual courtroom. Mr. Phoenix, we are ready for you.
Thank you, Your Honor. Good morning. May I proceed?
Yes.
If I could, I'd like 5 minutes for rebuttal time.
Yes, very good.
So this case is a little bit complicated. The gist of it is that it started in federal court, heavily litigated, and in the federal court, the judge entered summary judgment and ruled, however, for the bank to go to state court to get a foreclosure. And I think the language was that the state court was better suited to deal with that.
It seems like that the federal court didn't know how to really set a sail on the courthouse steps and do that process. Is that kind of what the issue was there?
Well, I think the federal court as a whole understood the case. Unfortunately, the case ultimately was transferred to a judge from Minnesota. So,
well, yeah, but it seems like the federal court ruled that foreclosure was proper. Is that right?
The judge from Minnesota did, yes, that's true.
Okay. All right. So basically, you have a federal court decision that says, you know, after hearing the case and what have you, saying that foreclosure by the bank was in order in the system. Is that right?
That's correct.
And then from there, the bank, because the federal court kind of said to you need to go to state court, the bank then came to state court and filed an action under Chapter 702 of the Florida statutes, relying on the full faith and credit of the federal court's decision, and was simply trying to get a sale date and a judicial auction. Isn't that right?
Well, the mechanism they used was the 702.10, the show cause foreclosure statute. So in order to avail themselves of that, then they needed to comply with what that statute required. So 702.10 requires a few things. Among them, of course, is that it needs to comply with 702.10, 702.015, and other parts.
Well, all that presumes that this is a fresh foreclosure action and talks about the attachment of the appropriate documents and things like that. But here we have an action that was in federal court. You have a federal court order basically saying that foreclosure is in order. And merely what the bank's doing is taking that order into the state court, expecting to get full faith and credit, which the law requires that they get, and proceed to a foreclosure sale is really, it seemed to me, what the stumbling block was. So, and then, you know, basically there was an order to show cause. You filed a motion to dismiss. The court basically heard the motion to dismiss, ruled on it, and ordered foreclosure and set a sale. And I know you found all sorts of irregularities with this process, but it seems to me, given the fact that the federal court did, you know, the lion's share of the work here, what was the need for the state court to replow that field?
Well, whether or not that's the case in Florida, under Florida law, all foreclosures must occur in equity. So in order for that to have occurred, then you need to comply with Florida law. So in this case, the bank chose to use the show cause procedures, the show cause statute. In order to do that, they had to comply with it. You have to comply with it. I'm sorry. I'm sorry?
I have a question for you.
Yes.
And my question is, what more did Regions have to prove once the state court held the show cause hearing that hadn't already been proven in federal court? What else did Regions have to do substantively?
So for one thing, under 702.101, there's a different burden of proof. So under 702.10, the burden of proof is no genuine issue of material fact versus preponderance of the evidence.
Isn't that what the federal judge had already found in its March 27, 2017 order?
Well, in that case, that cause of action was not under 702.10.
But 702.10 is not the statute doesn't create the cause of action. The cause of action is for mortgage foreclosure. The 70210 sets a procedure, doesn't it?
It's not merely procedural, no. In fact, actually, under Capel v. Tuttle's design bill, the court ruled that it's not merely procedure, but rather affords a substantive right. So, substantive
But
right.
the Tuttles and so forth deals with the distinction that Judge Morris just recognized, which is the difference between having sort of a fresh foreclosure versus show cause, why the full faith and credit should not, why this federal decision should not be given full faith and credit in the context of the foreclosure. And Regents had flagged a foreclosure claim and litigated it to conclusion, the specifically this March 27th order, and then brought it to the state court and said, we'd like to have a foreclosure sale, essentially, under the surplus statute.
Right, and they brought that under a variety of different theories, but one of them is the res judicata. Res judicata cannot be used affirmatively.
What about collateral estoppel?
Collateral estoppel, in order to use collateral estoppel, that means there had to be at least one issue that wasn't decided, at least one issue, and that's my biggest claim here. If you're using collateral estoppel, that means something had to be litigated, which is the fact here.
For purposes of collateral estoppel on a mortgage and the foreclosure claim, what point wasn't litigated in the federal court that would leave collateral estoppel unmet here?
Well, under 702.10, for example, the statute requires at a minimum that you have to comply with 702.015 certification of no. That wasn't done. And on top of that, under Florida law, all issues of equity have to be considered. So not all issues in equity were considered. So that also is required. That's under 702.01.
Merits defenses that the federal judge addressed?
I'm sorry?
Aren't your equity, what you were saying is an equity issue that the state court judge would have been required to address? Wasn't that addressed, that same argument on merits by the district judge?
The judge didn't. He didn't address those issues on the merits, I don't believe. For example, he never addressed the issues of the fact that payments were made and rejected, things like that. So none of those issues were addressed.
Were those issues raised in the federal court?
No, because actually the foreclosure, during the course of all payments were made. The foreclosure was brought by Regents for a completely different purpose, basically to force Periwinkle Partners to collateralize another note. Payments were all made. Periwinkle Partners was always in compliance. What they raised.
Hang on, let me interrupt with that. Was that raised in the federal court?
No, because what happened was, Your Honor, is that then over the course of 2 years of litigation, Periwinkle Partners continued to pay.
Why? Well, let me phrase it this way. Did Periwinkle have the opportunity to raise defenses in the federal court?
It did, but not this particular one, Your Honor, because
is it their fault for not raising a defense that they may have had, and by failure to raise it, it's waived?
No, but Your Honor, this is what I'm getting at. Is this all occurred actually after the case after the case's inception, and in fact, under Florida rules, it's a lot easier to amend a complaint, but you cannot amend a complaint or an answer or any pleading under federal law without amending the case management plan. You can't amend the case management plan 2 years into the case. So what happens
if there is a procedural problem and your client was not provided due process in the federal case, would your client have had the opportunity to challenge the judgment on appeal?
So this is the issue, and this issue, Your Honor, it's an odd one, but it straddles the judgment. So what happens is that just before the judgment, a year before the judgment, Regents starts returning the payments. Case is already going. So now all of a sudden, so that we couldn't raise that issue. So then what happens is they get a judgment, right? But under Florida law, you can't collect interest, for example, when payments were made and rejected. So what they did is under their judgment, they're collecting.
Mr. Phoenix?
Yes.
Argued to the trial judge in the state court in the surprise hearing that you made this argument about Periwinkle kept making payments. So result that Regions is principally relying on in that hearing. So how do we, after all this, the federal court having heard the arguments that were made here, and the state court having heard the arguments you're telling us the federal court didn't hear, how do we get there from here?
How do we get what? I'm sorry, I'm having a very hard time hearing you. I apologize.
A judgment that was first granted by the federal court after hearing all the arguments that you made to that judge. And you're telling us that the federal judge didn't hear your arguments about the equitable considerations associated with continuing payments, but the state court judge did, this record shows that he did. So after both of those, you know, the full faith and credit issue with the federal judge's findings, you're telling us that your client somehow was precluded from making a defense based on its continuing payments, but we know from the record in front of the state judge that he heard that. So where is the reversible error here?
So, okay, so one of the issues, I think there's several issues with reversible error. They use 702.10, they got to comply with 702.10. You have to comply with the statute if you're using the statute. That's one. Another one that I think is really important here is the order itself. The order itself said that that parent will have the right to file defenses by a motion at or before the hearing date, which constitutes cause for the court not to enter the proposed final judgment. It did that. Miracle Partners did that. And by doing that, it complied with the order. The order by itself in the case MDTR LLC versus Deutsche Bank, that case says both the statute and the trial court show cause or state that such action constitutes cause which precluded the entry of final judgment. The statute 702.10 precluded it unless you comply with the statute, and the order itself, we comply with the order. So and by the way, Regions Bank actually prepared that order and submitted it to the judge, but we complied with it. So if we complied with it, that's reversible. The judge has to honor his own orders, doesn't he? He shouldn't he? And then in addition to that, so in addition to that, and I know this, maybe I'm not making it clear, but the issues of the payments being rejected were after the case inception, and then Regions Bank included interest and so forth in its judgment in the state court. It can't do that. It can't do that without the court considering the equitable issue of whether or not interest should have been applied when the payments themselves were rejected, and they were rejected, but we couldn't raise that issue. We couldn't get there because the court wouldn't consider the equitable issue. It was an issue that straddled both cases. And then in addition to that, Your Honors, the judgment itself included language that it couldn't include. So it said under 702.10A, Florida statutes does not allow for a judgment to include a decretal authorizing rates of possession and an award of attorney's fees and to enter a deficiency judgment. Any final judgment of foreclosure entered under this subsection is for in rem relief only. But the judgment that the court entered at that hearing, following that hearing, included the deficiency judgment. That was error. So there are a number of errors here, but I think they all lead to the fact that Regions Bank was taking a judgment that it had under a different methodology, a different cause of action, and bringing it to state court and trying to run through 702.10 using that mechanism. But to use that mechanism, you have to follow the mechanism. And that was.
Are you saying that the final judgment of foreclosure that the project entered following the surplus hearing included a deficiency judgment?
It included a deficiency. I'm so sorry, Your Honor. It's for some reason I'm having a hard time hearing you, but it did include a deficiency judgment, yes.
Because I'm looking at that judgment, and paragraph 11 of it reserves jurisdiction to consider entering a deficiency judgment.
That's what I meant. Yes, that's what I meant. Not that it actually included the judgment, but to consider it.
But you're arguing that the trial judge couldn't, under 702.10, enter a deficiency judgment, which it didn't in the so-called hearing, or as a result of the so-called hearing. The deficiency judgment was later, right?
Well, the statute says, this is the exact language, any final judgment of foreclosure entered under this subsection is for in rem relief only.
Right, and so he could reserve jurisdiction to later consider the deficiency judgment. The judgment of foreclosure that we're talking about is only an in-rem judgment.
But it doesn't, but he's reserving in it the ability to do something that he's not authorized to do.
The statute doesn't say you can't do it later. He says, the statute says you can't do it in the judgment of foreclosure.
Well, I know this, I mean, the statute
Because
says
otherwise
it
you could
doesn't
never
allow anything beyond in rem relief. I'm sorry?
In-rem judgment.
It is an in rem judgment, but it has a caveat to enter writs of possession, award of attorney's fees, and enter a deficiency judgment. Those things are outside of in rem relief only. The statute is a creature of the legislature, it's a creature of state. We have to follow that statute. And it's good for good reason. The mortgagee actually is able to obtain a foreclosure faster. So in order to, the trade-off is that they need to comply with these elements.
But the trade-off is not that the mortgagee foregoes the right to pursue a deficiency after the sale. That's not what the statute says.
I mean,
show me where it says that, because I don't see it in the statute.
it says any final judgment of foreclosure entered under this subsection is for in rem relief only.
It doesn't say, and shall never, the mortgagee shall be forever precluded from seeking a deficiency if they avail themselves of this procedure. And it's a different count than a mortgage foreclosure. That's an in rem relief. Deficiency is a legal action for the deficiency after the sale. Your interpretation of the statute makes no sense to me.
Well, but if that were the case, then it would be identical to a standard judicial foreclosure. That would be no different. So, 702.01 doesn't have that kind of language in it. So, the purpose of this statute is, okay, if we're going to speed things up for the bank, then the bank's going to have to give up some things. And one of the things that they're going to have to understand is they get in rem relief only. That's it, nothing else.
The legislature had intended to cut off a commercial mortgagee's right to seek the deficiency after getting a judgment of foreclosure in rem. Don't you think the legislature would have told us that? As opposed to saying that the foreclosure judgment itself can't include a deficiency?
I mean, I'm just going by what the statute says, and I believe the case law that interprets it. I mean, the language, that is the language. It says it's for in rem relief only, not in rem relief and money.
But it's talking about the foreclosure judgment, which can be entered without resolving the other claims in a mortgagee's complaint, like the deficiency claim.
I mean, if that's the case, I don't know what to say. I mean, if the statute had provided for that mechanism, then I don't see why it would have included in rem relief and differentiated itself from the other form of foreclosure available under Florida law. I mean, we have to give the statute its effect.
Right.
That's no different than how you could.
For the language in the statute that says once you avail yourself of this in rem procedure, you, the mortgagee, are foreclosed forever from pursuing a deficiency. And I don't see that.
Well, okay, so under Florida law, under standard foreclosure, you could get a deficiency judgment theoretically, I guess, at provided for in the judgment, and then.
Oh, you don't know what the deficiency is till the property sells.
You can provide for it. You can provide for it, and then later file a motion to obtain the amount.
Mr. Phoenix, I'm going to go ahead and interrupt at this point because I've let you go over with all the questions that were asked. And if you want to reserve your 5 minutes, now's the time to take that break.
Okay, thank you. I'm sorry.
Very good. I'm going to take a moment here for a technical issue. I know Judge LeBrit's microphone seems to be a bit muffled. So before I call you, Ms. Stephanie, we will try and sort that out. I know our technical folks are listening in, and it may be that Judge LeBrit, that you may need to exit the courtroom and come back in, and let's see if that fixes it.
Okay, I'm going to do that.
You're on mute, Judge LaBritte.
I've played with my settings a little bit. Does this seem better? From a text
That's much better.
Yeah,
And-
way better.
And
Sorry about that.
Mr. Phoenix, I'll just let you know that I know you were having some difficulty hearing Judge LaBritte. So when we get back to your rebuttal time, if she wants to repeat any questions that she feels were not adequately answered, then of course she'll be able to do that, and I'll give you the time to address those.
Really appreciate it. I'm sorry for sticking my head in the computer like I was, but I was trying.
No problem at all. I was having some difficulty as well, but I, for the most part, could make it out. Ms. Anthony, we are ready for you.
Good morning. May it please the court. Stephanie Anthony for the Applee Regions Bank. Just to go over some of the history of the case, but not too much of the history because it has been quite long. When Regions Bank filed the district court action back in August of 2014, it sought in rem and personam relief against Periwinkle and several other obligors. There were 73 affirmative defenses and 12 counterclaims that were ultimately resolved by the district court and affirmed on appeal to the 11th Circuit. Part of what Regions was directed to do with respect to count 5 in the district court complaint, that judgment directed Regions to go ahead and get the sale in the state court for whatever reason. So when Regions filed the state court action, it was merely filing the action to enforce the dispositive orders that had already adjudicated the balance of the Periwinkle obligation.
Ms. Anthony, I just want to back you up for a minute to the district court's, the March 27, 2017 order. And I'm looking at it where the background, and the federal judge said that it had largely granted Regions' motion for summary judgment, which I think is all the counterclaims and most of the affirmative defenses you're talking about. I just want to make sure I follow the bouncing ball through this record.
Yes, Your Honor.
Okay.
And
then the purpose of the proceedings that resulted in the March 27, 2017 order was to specifically focus on the foreclosure, the interim foreclosure claim, and whatever defenses had not been disposed of in the earlier order on the summary judgment motion. Is that correct?
Yes, Your Honor.
Okay. I wanted to interrupt you only to get the handle on where exactly we were at the time the federal judge entered the March 27th order.
Yes, Your Honor. And this document was one that I plan to point the court to when the prior questions related to whether or not the payment issue had been brought in the district court. They were, in fact, and there was a discussion in the district court's memorandum in order that you just directed me to, document 405, around page 3 of that, where the court noted that technical defaults may not give rise to a cause of action for foreclosure. So that had definitely been brought up in the district court action. In fact, counterclaims had been amended several times in the action. And that was something that had been considered by the court when it ultimately entered this opinion. And I think what was significant for the district court was the fact that the defendants had not paid ad valorem taxes on the property in 2013, and certainly that is a monetary default. So,
right before the conclusion in the federal judge's order, the judge notes that the court Periwinkle asked for a balancing of the equities, and the federal judge specifically found that the equities lie with Regions and that it was entitled to foreclose on the Periwinkle loan because of undisputed defaults being the tax issue, correct? That's what, yes. That's the undisputed default that he's referring to.
Yes, Your Honor, and that's on page 6 of that document 5. And so when you go on to read down to the decretal paragraphs, number 3 states that the plaintiff is entitled to a judgment of foreclosure as to periwinkle property under count 5 of the complaint. And then later we were directed to proceed with, I guess, getting the sale set by the state court. So when the action was filed for the state court action, Regions was attempting to do as it was directed to get a sale set on a foreclosure judgment that had already been adjudicated by the district court. And we asserted that that was something we were entitled to, and that the state court should give the federal judgment, should recognize that under the full faith and credit clause. And then we had also used res judicata, collateral estoppel, law of the case as legal principles that would support the bank's entitlement to a judgment in connection with the state court action, so we could go ahead and get the sale. And that is what happened. The defendants filed an omnibus motion, and there was a 2-hour hearing on their defenses, which ultimately were not successful, and the court entered its judgment on the complaint that was filed in the state court and thereby set the sale. I know the defendants have raised some issues with respect to the form of the show cause order. We believe that while it doesn't track the amended version of the statute perfectly, it certainly provided that periwinkle has the right to file defenses by motion, which it did. And that in number 7 of that order, it states that if periwinkle files defenses by motion, the hearing date may be used to hear such motions. And when the statute was modified in 2013, it appears the intent was to reduce the hearing time from 1 hearing, or from 2 hearings to 1. So prior to the amendment, if anything was filed, then the judgment wouldn't be entered pursuant to the show cause, that initial hearing. There would be another hearing. But
Ms. Anthony,
yes.
I'm going to jump to another point that your opponent raised. His argument, as I understand it, is that once Region availed itself of the show cause procedure in 702, it was foreclosed from ever seeking a deficiency judgment. And my understanding of the basis for that is the language in the statute that says the foreclosure judgment shall not provide for a deficiency, words to that effect. Can you address that, please?
Yes, Your Honor. That is not what the statute says. 702.10 at sub 1A 9B, I believe, states that any final judgment of foreclosure entered under the subsection is for in rem only. The next sentence, however, which was not stated previously, is that this subsection does not preclude the entry of a deficiency judgment where otherwise allowed by the law. And then goes on to say that the legislature intends that this alternative procedure may run simultaneous with other court procedures. So this is just a vehicle to expedite the foreclosure process. And I think it was 2013 was when we were flooded with a lot of foreclosures. And so that's my understanding of the statute, is that it was amended to have foreclosures more expedited, and to the extent there were no defenses or defenses were waived, the foreclosure judgments would be entered pursuant to this vehicle, this show cause hearing. But that did not, in fact, preclude a creditor such as Regions Bank from pursuing the entry of a deficiency judgment. Did that answer your question, Your Honor?
Yes, ma'am.
Thank you. So the judgment that was entered in the state court action, all it did was reserve the court and the bank's right to proceed with attempting to obtain a deficiency judgment or get writs of possession or whatever is needed in a after a subsequent hearing or after a proper motion was filed. We believe that all of the potential defenses and anything that could possibly have been raised were in fact considered in the district court action. The defenses filed in the state court action would have already been considered, and to the extent they were considered at that show cause hearing. The defense has stated that we are not entitled to use res judicata. However, we cited in our papers Lucky Brand Dungarees Inc. versus Marcel Fashions Group, which is the 2020 Supreme Court case that says defense preclusion is a valid application of res judicata. So we would disagree with the defendants or the appellant's position on that application of res judicata. And we cited our Pettyjohn versus Dade County case, obviously, for full faith and credit that we believe that the state court had to give to the district court judgment. And that is the basis of our papers, which I would rest on unless your honors have any other questions for me.
Very good, Ms. Anthony. Mr. Phoenix, before you begin, Judge LaBritte was, because there was some trouble with the microphone, was there anything that you wanted to follow up on with Mr. Phoenix before he starts his rebuttal 5 minutes?
I'm good right now. Thank you.
Mr. Phoenix?
Yeah, so one thing I'd like to address, at least minimally, is the language in the statute under 7.2.10. It does very clearly say any final judgment of foreclosure entered under subject and is for in rem only. And then it's true, the next section says this subject does not preclude the entry of a deficiency judgment where otherwise allowed by law. Well, that's presumably 702.06, which requires that, or allows that you could sue a common law in a separate suit.
But that issue is not really ripe for us, is it?
No, not really.
There's no deficiency. There's the judge in his final judgment reserved jurisdiction for deficiency proceedings if your client wasn't discharged in bankruptcy. But he didn't say, I find entitlement to deficiency, but I'm reserving to amount. I mean, he didn't do anything to rule on the merits of that, correct?
No, I agree with that. But one other thing I'd like to bring up also is counsel just cited this, the Supreme Court, federal Supreme Court case, Lucky Brand, but she's sort of not exactly explaining it. In that case, res judicata was raised as a defense to an affirmative.
Mr. Phoenix?
Yes.
What if we take res judicata off the table and only look at full faith and credit and collateral estoppel? Do you still maintain that the state court judge should not have given full faith and credit to the findings that the district court made in the foreclosure judgment and the order on rehearing?
Yes, because the collateral estoppel, I think, is the easy one. Collateral estoppel says that there must be one other issue to resolve. Like we've resolved everything, but one issue stands out. So that's my whole point, is the difference between the foreclosure that they got in federal court and the one they got here are different under different procedures. And under 702.10, in order to obtain foreclosure, you have to allege a cause of action to foreclose. It has to be verified, and you have to comply with 702.015. It also has different burdens of proof and so on and so forth. But at a minimum, they did not comply with 702.015, that's for sure. And then in addition, going back to the judge's order, the judge said in his order, that's what it says. If we file a motion to dismiss, that precludes entry of the judgment, but it didn't. So we complied with the order, but the judge didn't honor his own order. So that's an issue. So as to the collateral,
are you contending that that is a permanent bar to a
no,
judgment of foreclosure under that statute if some defenses are raised?
no, I'm not. But it seems to me at the minimum that it would deny the motion that was being heard because we complied. So that motion was for an entry at that point. So then that means I think that you would go down a normal track where some of these other things would have been considered. Because remember, the burden is placed under the show cause statute on the defendant. So in that's a significant difference, by the way, in this statute versus.
Well, let me raise hypothetically, and I'm not sure this is really a hypothetical under the facts of this case.
Right.
If the federal court ruled that Regions is entitled to proceed to foreclosure, and your client files a response to the show cause order that says, no, you shouldn't enter a final judgment of foreclosure because we have a lot of defenses and the federal court never got to them. Under full faith and credit and comedy and collateral estoppel, isn't the trial judge in the state court entitled to say, if you were aggrieved by anything that happened in the federal court, you needed to take it up on appeal. You in fact had an appeal and the final judgment was foreclosed. So you cannot litigate things that could, should, would have been litigated in the federal court. Isn't the circuit court entitled to rule that way?
It is if it was given full faith and credit to a judgment that was based on the same cause of action. I mean, even that Lucky Brand case kind of goes through that. There were 3 lawsuits in that case. And
the cause of action was always that was at issue in all of this was Regions' entitlement to foreclose to remedy of foreclosure, that interim remedy provided by the mortgage and the law. There wasn't a different cause of action for foreclosure than in the state court than there was in the federal court, was there?
Yeah, the 702.10 by its own language says.
But it's the same foreclosure of the same mortgage for the same default against the same defendant. What's different?
It's not the same cause of action. The cause of action under 702.10 and essential requirements of law require us to actually honor the apply of facts to the statute. Under the statute, 1, you have to allege a cause of action to foreclose. 2, it has to be verified. And 3, it has to comply with 702.015. So addressing issue for collateral estoppel, full faith and credit, and your question all in one, they did allege a cause of action foreclosed in federal court, but they didn't do the other elements. There's 2 more elements left.
Mr. Phoenix, I think we have a handle on your argument. You heard the timer go off, so I'm going to give you 30 seconds to wrap up.
I really appreciate it, Your Honor. So I think the gist of it is this. The court may be looking at it like these are technical arguments, but we go to court. I think all of us, we go to court we're hoping for a science, and sometimes we don't get it, but there are rules, and the bank should at least follow those rules at the minimum, and that's the gist of the argument.
Very good. Thank you very much, Mr. Phoenix and Ms. Anthony. Just for planning purposes, we are going to hear the next case, which is Ryan versus Raleigh. We will then take, or Roll, we will then take a 10-minute recess after this next case. So with that, Roll, Ryan versus Roll or Raleigh, and I'll let counsel tell me how it's pronounced.